Now by way of introduction, I think it's always important to restate again and again that detaining a person in prison is one of the harshest displays of state power against an individual. I go into prison here in Brussels every other week to meet and listen to detainees in their cells. And we're seeing the real consequences of this carceral fever in Europe, of the injustice, the inhumanity, the striping away a person's human dignity. And I think also what Anne-Sophie in the previous call very well described, this choc de l'enfermement, the shock of incarceration. And we're also seeing prison populations exploding. In Belgium, hundreds of people are sleeping on the floor on mattresses right now due to lack of beds, literally, as we heard is the case in France too. And here the government's master plan, as they literally call it, and solution is to build new prisons. And we heard in the session before that this is something ministers across Europe are interested in budget to build new prisons. But whatever the conditions, prisons are inherently violent, and we are witnessing a rapid and very worrying extension of the logic of detention and the use of incarceration, of restricting the fundamental right to liberty through, for instance, the adoption and generalization of police powers and the use of administrative detention powers, such as we saw here in Belgium during the height of the pandemic, where the police was using these powers to break up demonstrations and detaining people for up to 12 hours without judicial oversight. And we know that police custody is often a pipeline to pretrial detention. We're also seeing the extension of the carceral logic in policies promoting alternatives to prison, with a special focus, for instance, in interest by governments on electronic monitoring to keep people imprisoned at home. But is this simply enabling the expansion of carceral control outside of the prison walls? Is it further deepening the existing structural inequalities that we see in prisons? And is it actually perversely, in turn, further reinforcing the carceral logic and recourse to prison? Yesterday, also, we heard about how certain groups, in particular European Muslim communities, are targeted by constant surveillance measures, which speakers agreed were a form of imprisonment through suspicion. So many forms of detention that participate to this carceral fever. And we are seeing how different criminal justice policies, whether aimed at reducing pretrial detention and incarceration, or aimed at promoting other security-driven objectives, largely follow the same carceral logic, with no regard for the devastating impact it has on the lives of those incarcerated and their communities and society in general, as well as the rule of law. And now we've just heard about how the EU's trying to work to limit pretrial detention, but the difficulty it faces in terms of using as a tool the law alone. And also the challenges at national level in following up and effectively implementing regional recommendations, because this is much more than a legal reform issue and is likely to be swamped, any efforts really are likely to be swamped by the EU's broader policy machinery, which is driven by such a powerful security agenda, as we heard in our panel yesterday. So as part of our conference, inviting you to reimagine criminal justice, let's reconsider this approach. And the aim of this panel is to find our way out of the carceral logic. Again, very ambitious, but we really need to discuss this. And so we've brought together a terrific group of speakers who will bring different and I believe complementary perspectives that draw up a broader picture of Europe's carceral fever and try to engage us into thinking of how we can get out of it. I've asked our speakers to be thought-provoking, to inspire reflection and debate with everyone here. So again, set a very ambitious agenda for all of our speakers, which I'm certain they will live up to. And before I hand over, I'll very briefly introduce each speaker. So we have with us Laura Garius, who is policy lead at Release UK. Release is the National Centre of Expertise on Drugs and Drug Laws in the UK, and Laura is a criminologist and prior to joining Release was a senior lecturer in criminology at Nottingham Trent University. We also have Martin Zweed, I'm sorry if I mispronounced your name, Martin, who is the coordinator of the Strategic Litigation Program at the Helsinki Foundation for Human Rights in Poland, and is a constitutional law specialist. We also have with us Sean Binder, a human rights campaigner. Sean is also a rescue diver and trained maritime search and rescuer who volunteered as a coordinator of civilian rescue operations, both on land and at sea in Greece in 2018. And then we have Julien Fischmeister, who is currently writing his PhD on criminal law and is also an active member of the French section of the Observatoire International des Prisons. So I'd like to start by asking Sean to remind us all about what we are here, what we want to fight against, what it means to be detained, and share with us insights into his firsthand experience of being held in pretrial detention, and to also explain the charges that you face, and reflect on how your experience is representative of broader social dynamics and the interplay between criminal justice powers and migration policies and related broader political and social narratives. Thank you, Sean.
Thank you. Hi, yeah, so my name is Sean, and I come to this, I suppose, given my background in helping coordinate search and rescue on the island of Lesbos, which, as you will all know, is considered a hotspot or a primary entry point for folks who seek asylum, primarily from the Middle East and from North Africa. Now, that work brought me in close cooperation with the authorities, or so I had thought. But despite the, I suppose, necessary nature of civilian search and rescue on the island, I was arrested. I was arrested in 2018 while doing search and rescue by the police with whom I had worked. They had arrested us without really giving much information as to why exactly. They arrived at 2 a.m. in the morning, and we were on the southern tip of the island of Lesbos. They took us in for questioning, investigated, or rather searched our warehouse and my home on the island, and then released me 2 days afterwards, pending further investigation. Now, at the time, we had felt that this was, if it hadn't been so serious, more or less a joke, insofar as the murmurings that we were hearing, or the narrative that was beginning to form around our arrest and subsequent investigation, was that we had stolen a military jeep, that we had attempted to infiltrate a military base, that we had attempted to steal state secrets. However, this appears to have been exactly what the authorities believed, and 6 months after our initial arrest in February of 2018, I was arrested again, and this time held in pretrial detention for over 100 days on the strength of a number of fairly heinous accusations, some of which have now become charges. And those are, among others, being part of a criminal organization, money laundering, forgery, fraud, facilitation of illegal entry, and of course, espionage or spying. All of which are, of course, incredibly serious crimes, and if we're found guilty, which is yet to be determined, we will spend 20 years in prison. The question you might be asking yourself is, well, what did you do? And interestingly, as I suggested, we had worked quite closely with the authorities. And so from our perspective, what we had done was only what is necessary, which is providing medical intervention in an environment where there are far too few resources being devoted to medical interventions. And to give you a flavor of the difference between what we're charged with or accused of and what we actually did, I can rely exclusively, for example, on the facts brought or the investigation's own arguments. And the investigation, for example, says that I have committed roughly 12 counts of facilitation of illegal entry, half of which occurred before I was on the island of Lesbos at all. Some of the charges, for example, espionage, are even more tenuous and relate to, say, the fact that I used WhatsApp, which is an encrypted communications service. And so there's very little evidence here. And I think that's more or less the key point. Because by reference to the law, we have done nothing wrong. In fact, there is a requirement under international maritime conventions, or say the Universal Declaration of Human Rights with the right to seek asylum, or the ECHR for the right to life. The kinds of work that we did are necessary and sanctioned. The power then of pretrial detentions, where you can be put into prison without the need of proof, because all of that will come out in the wash, as it were, once we go to trial. The use of pretrial detention is to cast a shadow of doubt, even in the absence of any proof of wrongdoing. And this is exactly what we're seeing on the island. Our case, unfortunately, is not to be seen in isolation. There have been at least 171 individuals in over 60 prosecutions across at least 13 member states, and that is only up until 2019. So that is the time of 2014 to 2019. Now, the research platform that discovered all of these prosecutions, Rizoma, is no longer conducting this kind of research, but it will resume, from my understanding, by the European Parliament in this summer. However, that is already a huge number of people. 171 individuals across 30 member states is a significant impact. And I think that there's even a more outsized impact insofar as these 171 individuals, I think, serve as a message. And that is that even if you are doing bona fide search and rescue or humanitarian interventions in the European Union, you might still face prosecution. It's worth, of course, noting that of these individuals, those who have actually made it to a trial, and it has always concluded in acquittal. So, of course, it is confirmed that the law is on our side. But the uncertainty in waiting, the outside legal costs, the personal and professional cost of being in pretrial detention are so high that the real purpose, I think, is to serve as a chilling factor or chill effect. And we see that exactly on the island of Lesbos today, for example. The day after our arrest, there were no more search and rescuers on the southern part of the island. Today, 3 years on, there is no search and rescue at all on the island of Lesbos, at least not coming from registered search and rescue organizations, which had previously been very operational. And as I've previously stated, complemented the authorities and provided services that would not have existed otherwise. So I think, just to recap that so far, the kinds of use of pretrial detention really serve as a chill effect on broader activity. And the point here is that you're not found guilty. And so it can be used as a measure immediately. And it relies, therefore, if not on the law or on the facts, it relies, I think, on a cultural element. And I think this is an aspect of carceral fever that we could really dig into, and that is its broader connection to a narrative or cultural trend that we see. Keeping me in pretrial detention had the benefit from the prosecution's point of view of casting doubt. So the kinds of response I would get from folks who were first being introduced to my case would be, well, you must have done something to be in pretrial detention. The use of these tools is so official and therefore imbued with a legitimacy that is really difficult to overcome in a conversation or in any other kind of intervention. And I think this has a very unfortunate but very effective cyclical effect on the broader context. I'm being arrested not because I did something wrong, but because there's a broader narrative that seeking asylum is in some ways threatening or wrong. This cannot be viewed outside of the context in which asylum seekers are cast as threats, economic migrants, or generally themselves networks of smugglers or criminals. The interesting thing, of course, is that, perhaps not interesting at all, but perhaps the most frightening, is that asylum seekers are themselves being detained for that very reason. We see this a lot. We see asylum seekers who are being prosecuted for offenses such as trafficking, even though these offenses were originally designed to protect asylum seekers. The frightening thing here then is that because of these prosecutions, They cast a doubt over the legitimacy of seeking asylum, of helping asylum seekers, which then justifies the kinds of prosecutions we see, which then, of course, legitimize the narrative in the first place. And so the cycle goes. What I'm trying to just conclude here, because I might be heading towards time, my point here is that there is a real material cost to pretrial detention in the form of dissuading bona fide search and rescue and other humanitarian activity. But it also must bleed into the broader cultural narratives that really define our policies and help, I guess, give impetus to our more securitized policies, which is all the more frightening because they feed off each other and they strengthen each other, despite, of course, not having any legitimacy in the facts of what causes migration, what causes smuggling, what causes trafficking, unfortunately. So they don't get to the root cause of the problem in the very first place. Thank you.
Thank you. Thank you so much. And thank you also for that, the clarity that you bring on such a personal and deep experience that you've personally lived. I think it's really interesting to tease out that interplay with those social narratives and that generalized suspicion of migrants, that only certain migrants, where they come from certain regions, are legitimate, and that ability in that way to legitimize the use of criminal powers against volunteers such as yourself when you are coming in assistance of these people. And it really takes us beyond that sort of strict framing of pretrial detention being a legal issue, and really as pretrial detention being a state power that can be used and weaponized against certain people. And I think illustrates as well, very much for those who were able to attend the discussion yesterday, Noura's comments. And if you didn't attend, there's a recording that will be available, and I really would encourage you to listen in. It was a great discussion. But really Noura's comments yesterday calling for caution on using government narratives because they legitimize deeply harmful policies. In the case of Austria, policies driven by Islamophobia, for instance. So thank you very much, Sean, and I'll come back to you. But first, I'll hand over to Julien, who will be speaking in French. So please use the interpretation button at the bottom for those who don't understand French. But could you develop further that interplay that you see in France between criminal policy and other political agendas, and in particular that relationship that you studied between detention and expulsion of migrants? And also, would you argue that criminal powers, and specifically powers of detention, are instrumentalized to further an anti-migrant policy? Thank you, Julien.
Merci, bonjour à tous et toutes, et merci de me laisser la possibilité de parler en français, c'est quand même plus confortable pour moi, donc j'essaierai de parler doucement. Donc, je ne sais pas si on peut parler d'instrumentalisation, alors on pourrait, mais avec certaines nuances. Ce qui est certain, c'est qu'une fois qu'une personne étrangère, donc vraiment une personne non pas issue de l'immigration, mais une personne vraiment qui n'a pas la nationalité française en l'occurrence, une fois qu'une personne étrangère a mis le pied dans le processus pénal, ce qui est certain, c'est que ça va considérablement impacter son futur sur le territoire et ses possibilités de mener une vie familiale et personnelle normale. Ça, c'est une réalité. C'est parce que c'est à partir du moment où la personne rentre dans le processus pénal que l'administration, donc pour le coup les services de l'État, déconcentrés de l'État, va vraiment profiter de cette période de détention pour faire grossir les chiffres des expulsions. On m'a demandé d'être un peu radical et trivial, donc j'en profite. C'est vraiment ça la logique. C'est-à-dire qu'il y en a toute une population que l'État français souhaite se débarrasser, dont l'État français souhaite se débarrasser, et pour les services déconcentrés de l'État, la période de prison constitue cette opportunité. Voilà. Autrement dit, ce qu'on peut dire, c'est que les politiques migratoires se servent de la prison pour atteindre leurs objectifs, et ça se manifeste de deux façons relativement chronologiques. C'est-à-dire que d'une part, les services de l'État ne font rien ou presque rien pour permettre aux personnes détenues, aux personnes incarcérées, de maintenir leur situation régulière. maintenir leurs papiers en règle, hein, pour parler autrement, pendant la détention, voire même à une personne simplement de demander des papiers pendant la détention. Et d'autre part, ils vont mobiliser toute une série de dispositifs, et notamment une notion qui est très difficile à comprendre et à cerner en droit français, qui s'appelle la menace pour l'ordre public, pour justement expulser les personnes à l'issue de leur peine de prison. Voilà. Donc c'est une notion qu'on peut mobiliser dans toute une série de cas de figure, et notamment pour des délits, pour des infractions de très très faible gravité. Voilà. Donc ça, c'est vraiment quelque chose qui est structurel, qui est organisé, pas qu'en France, hein, c'est le cas dans d'autres pays, mais qui fait que une fois le pied dans l'engrenage de la pénalité, les étrangers sont largement discriminés de fait. Voilà. Ça va engendrer une part de plus en plus importante de sortants de prison vers les centres de rétention des étrangers, vraiment les centres administratifs qui sont utilisés le temps de procéder à l'expulsion des étrangers. C'est environ 25% aujourd'hui des personnes qui sont dans ces centres qui sortent de prison. Et ça, c'est vraiment une proportion qui est exponentielle, quoi, qui était bien plus inférieure il y a encore quelques années. Voilà. Alors, sur un autre registre, essayer de comprendre un petit peu de quoi on parle quand on aborde la question des étrangers détenus. Moi, j'ai souvent pour coutume de présenter les choses comme ça, parce que c'est assez lisible, on va dire, comme tableau. C'est-à-dire, ce qu'il faut comprendre, c'est que dans les prisons françaises, il y a à peu près un quart, un détenu sur 4 qui est étranger. Voilà, donc un quart des étrangers, un quart des détenus qui sont étrangers. Quand on regarde les chiffres des condamnations, c'est-à-dire vraiment le nombre d'infractions qui ont été commises chaque année, et d'infractions surtout qui sont punies, on voit que les étrangers ne sont pas 25%, ils sont 15%. Donc déjà, on a un écart qui est assez important. Et ça, on va essayer peut-être de l'aborder, on pourra peut-être en parler. Or, les étrangers, dans la population vraiment générale, dans la population française, ils ne représentent que 8% de la population. Donc on a vraiment des écarts qui sont très, très importants. Le premier écart, peut-être qu'on doit convoquer un peu la sociologie, notamment la sociologie américaine du milieu des années 1900. Les deux sociologues qui étaient George Roche et Otto Kirchheimer avaient déjà montré les liens, la corrélation qu'il y avait entre la détérioration du marché du travail et la montée des effectifs emprisonnés. Puis il y a eu énormément de travaux qui par la suite ont montré que les liens qu'il y avait entre l'immigration et la pauvreté, les liens qu'il y avait inévitablement entre l'immigration et la délinquance, et comment finalement les États, en l'occurrence, c'est le cas aux États-Unis dans des proportions encore plus importantes, mais c'est bien sûr le cas en France, comment les pouvoirs publics finalement identifient toute une population qu'elle qualifie d'indésirable et qu'elle souhaite mettre à l'écart et voir de la société, donc en prison évidemment, et ensuite en dehors du territoire français. Donc il y a un contexte vraiment général de précarité sociale, professionnelle, administrative, parfois même familiale, qui fait qu'on a une population davantage exposée à la délinquance, mais donc dans des proportions plutôt à hauteur de 15%, qui ne viennent pas expliquer les 25% d'étrangers en prison. Là, c'est vraiment le fonctionnement de la justice pénale qu'il faut interroger, qu'il faut remettre en question également, qu'il faut parfois dénoncer. Bon, tout dépend, chacun opère sur son terrain. Et ce qu'on peut comprendre, c'est que là, du coup, il y a vraiment une discrimination qui se joue. C'est peut-être plus à ce stade, une discrimination qu'on ne doit pas mettre sur le dos individuellement des juges. On ne peut pas dire que les juges individuellement sont racistes, mais on peut dire que le fonctionnement de la justice pénale présente vraiment un traitement vraiment différencié à raison de la nationalité. Ça peut se manifester, et après je passerai la main, mais ça se manifeste vraiment très clairement par trois choses. D'abord, on peut voir que les juges ont davantage recours à la détention provisoire vis-à-vis des étrangers, dans des proportions vraiment assez importantes, c'est-à-dire qu'il y a 41% des ressortissants étrangers qui étaient en détention provisoire en 2020, et c'est 31% des Français. Donc on a déjà un écart de 10 points, alors qu'on sait que, encore une fois, les étrangers ne commettent pas des crimes ou des délits de plus forte intensité. Ils ne représentent pas ils ne sont pas auteurs d'infractions plus graves que les Français. L'action des juges présente des caractéristiques aussi discriminatoires, en ce que les peines prononcées à l'encontre des étrangers sont globalement plus sévères et souvent plus longues aussi. On voit que dans 49 des cas pour les ressortissants, les justiciables français, il y a une peine privative de liberté qui sera prononcée. C'est 60% pour les étrangers. Donc il y a vraiment un écart encore d'une dizaine de points. Et enfin, du coup, cette politique est également discriminatoire parce que les étrangers ont beaucoup moins accès à des mécanismes d'aménagement de peine, donc des mécanismes de probation, des mécanismes alternatifs, on va dire, alternatifs à la prison. Et là, c'est très flagrant quand on lit les statistiques disponibles, c'est-à-dire qu'on voit que les étrangers ne sont que 10% des personnes suivies à l'extérieur, contre, donc, comme je le disais, 25% des personnes derrière les barreaux. Voilà, donc il y a un écart vraiment net, il n'y a que 10% des personnes qui sont suivies à l'extérieur, sous le régime du bracelet électronique, sous le régime de la semi-liberté, sous le régime de la libération conditionnelle, qui sont étrangères. Voilà. Donc, couplé avec d'autres, tous ces éléments nous font voir que ce qu'on appelle le racisme d'État, ce que certains sociologues ont appelé le racisme d'État ou la pensée d'État, comme le disait Abdelmalek Sayad, touche également la sphère pénale. Ce n'est pas simplement la sphère pénale, c'est vraiment un tout. Et peut-être pour finir, ce tout, il est pas simplement dans les réflexes de la justice, mais il est aussi dans le discours public, il est dans les discours politiques, il est dans les trajectoires politiques qui sont menées par les gouvernements successifs. Ce n'est pas seulement quelque chose de récent, c'est quelque chose qui a une quarantaine d'années en France. On a vraiment une accumulation de textes, parfois contraignants, mais parfois même de textes de soft law, qui viennent simplement expliquer à toutes les autorités décisionnelles qu'il faut avoir une attention vraiment très importante vis-à-vis des étrangers détenus, qu'ils représentent vraiment une menace pour la sécurité et pour la nation et pour les intérêts fondamentaux de l'État français. Et donc vraiment, il y a tout un amalgame en fait, qui est construit autour de ça, qui font que chez les juges aussi, ne pas oublier que les juges sont des hommes et des femmes comme tout le monde avant tout, donc chez les juges aussi, il y a ce traitement différencié qui va s'opérer. Voilà.
Merci beaucoup, Julien. Thank you very much for explaining as well how very much like Sean, how this picks up detention, use of detention, criminal justice policy generally is really reflective of broader social and political narratives. I'd like to now hand over to Laura and to talk about briefly the very extensive research on the war on drugs in the UK and how that those policies have had a profoundly unequal outcome across racial groups. And yeah, to pick up in particular on Julien's concept of that, well, not Julien's, but the concept of racisme d'État or institutional racism, if I can translate it in that way, that Julien described just before, and how you think this is specifically driving and contributing to Europe's carceral fever. Thank you, Laura.
Thank you very much. Can you hear me okay?
Yeah.
Fantastic. And thank you to both of the previous speakers. Very difficult to kind of live up to those talks, some fascinating information, but I will try to briefly summarize the anti-drug legislation and how that is racially motivated. And so the short answer to the question is yes, drug policies were and are a form of racial control. The war on drugs, which I'll come on to in a bit more detail, is rooted in racism and xenophobia. Over the last 50 years, we see that this legislation has entrenched racial and social injustice in the criminal justice system. And also drug law enforcement is still one of the sharpest tools in the box for racially biased policing and sentencing. And just thinking to the origins of the war on drugs as well, in the UK 50 years ago, we had the Misuse of Drugs Act 1971. This wasn't the first piece of legislation to control certain substances, but it is the one that to date criminalizes many young people in the UK. And Release, which is the organization that I work for, Release was established to respond to what they saw as policing of the other, people in countercultural movements, people in poverty, young people. And also they were enraged by the racist element that they saw in policing. And they were seeing this applied to newly arrived migrants, predominantly Black and brown people who were being repeatedly searched and arrested by police. And Release believed that these new drug laws and being selective about which substances were controlled was actually an extension and another way to harass and criminalize marginalized and racial minority groups. And across the Atlantic, a similar scene was playing out in the USA, with President Richard Nixon declaring his war on drugs in the same year, 1971. And the US war on drugs is undoubtedly a major influence in the development of punitive drug policies around the world. We can't deny that. And it was decades later that we came to understand that the big war on drugs began not about drugs themselves, but it was a policy targeting the people who were perceived to use drugs. And it was Nixon's former aide who said that we had two enemies, and this is a quote, "We had two enemies in the US, the anti-war left and Black people, and we knew we couldn't make it illegal to be against the war or Black, but by getting the public to associate hippies with cannabis and Black people with heroin, and then criminalizing both heavily, we could disrupt those communities." So we have evidence that the war on drugs was founded in, as I say, racism and xenophobia. But that also kind of bleeds through to today. We see that our drug policies are far more to do with who is perceived to use drugs than the drugs themselves. In a number of examples, but I'll choose three for brevity, we see this in the classification of drugs. So whether drugs are classed as A, B, or C, which is about how severely they are punished, bearing very little relationship at all to the relative harm of those drugs. For example, we see psychedelic drugs in class A, the most severely punished, but actually on scientific scales, these are the lowest harm drug to society and individuals. So this speaks to our punitive attitude towards recreational drug use. Secondly, we see this discrimination in the way that some drugs are medically regulated and prescribed and others are not. A very famous example being that if the principal users of crack cocaine were wealthy older white men and the principal consumers of Viagra were poor young Black men, then crack cocaine would be easy to get with a prescription and Viagra would get 5 to 10 years behind bars. We also see it in the different sentencing and thresholds for the different forms of the same drug. So here I'm thinking about the difference between crack cocaine and powder cocaine and how they are sentenced, especially in the US. These are two forms of the same drug, no significant chemical difference, but a real stark difference in the sentencing laws for their possession, based on who is perceived to use them. And we see the disproportionate targeting of African Americans in this instance and those living in deprivation. But that's a little bit about the origins there and how that's still, as I say, bleeding into today. But what is the harm that's been caused and what is today's situation? I'm mainly going to be talking about the UK and England and Wales, but I understand that this is a pattern echoed throughout many countries in Europe and beyond. So Transform, the organization, have estimated that over 3 million criminal records have been issued under the Misuse of Drugs Act, 1971, and that people have been sentenced to well over 680,000 years in prison since 1986 alone. We know that currently 16% of the current prison population in England and Wales are sentenced for drug offences. We know that criminal records and indeed incarceration can have devastating impact on anyone who is the receipt of this punishment. Future employment opportunities are damaged, future education can be interrupted or damaged opportunities, visa and travel, in some cases access to housing and parental rights and access. But what we also see, and those are harmful to anyone who experienced those consequences, but what we see 50 years on from the beginning of the war on drugs is that communities of colour are still at the front line of the war. And that's true for the UK, the US, and many countries around the world. In England and Wales today, if we take a brief look at the statistics, they are extremely dismal reading. So people defining as minority ethnic are 3.5 times more likely to be searched than white people, particularly pronounced for Black people, who are 7 times more likely than white people to be stopped and searched by police. And the disparity here is the search for drugs. So the search for drugs is driving the racial disparity in these figures. The search for drugs is 69% of all searches across England and Wales. So it really is the search for drugs that's dominating those police powers. So I have a quick couple of rhetorical questions to see if we could possibly explain our punitive drug policy and the harms that they cause. So can the disparity in stop and search be explained by existing trends in drug use? The answer is no. So ethnic minorities are not more likely to use these substances, in many cases are less likely to use these substances than the white population. When people are stopped and searched by police, Black people are less likely to be found in possession of drugs when searched compared to the white population. And then when they are caught in possession, they are subject to harsher sentences, which I'll come on to. We also see disparity in the execution of these searches and arrests. So Black people are 6 times more likely to have force used upon them, 9 times more likely to have tasers used on them, 3 times more likely to have a spit and a bite guard used on them compared to their white counterparts. So that racial disparity we see begin at stop and search, follow into prosecution, conviction, and sentencing. We did a paper, which I encourage you to have a look at on Release's website in 2018 called The Colour of Injustice. And we looked in detail at the disparities in drug law enforcement and sentencing. We found that Black people were prosecuted for drug offences 8 times the rate of white people. White people were much more likely to receive an out-of-court disposal, such as a community resolution or a warning or caution compared to Black people. And Black people were sentenced to immediate custody for drug offences at 9 times the rate of white people. So this speaks to a policy that is much more about social and racial control than anything else. I want to quickly mention intersectionality. We also see a particular disparity for Black women who in Crown Court sentencing analysis are 25% more likely to be sentenced to custody at Crown Court for drug offences than white female counterparts. We see our sentencing council's own analysis where they control for other factors associated with drug offences that an offender's ethnicity is associated with a significant difference in the likelihood of receiving immediate custodial sentences. And also mentioning fair trials here in work that is not specific to drug offences, but we also do know in the UK that pre-trial detention is racially disparate. And we see that in their 2020 research on fair trials, so do have a look at that. Another question quickly, is drug law enforcement tackling the drug kingpins? So have we got these punitive policies because they're aimed at the heads of organised criminal groups? No, is the answer. Drug law enforcement is almost entirely focused on low-level possession offences. So almost 80% of drug offences recorded by the police have been for minor possession offences. It's estimated as well that 1 in 3 of all police stop searches are for low-level personal cannabis possession alone. Is there evidence then that our current drug policy is an effective deterrent? Surely then there's evidence that this is working. The answer is no. It costs us 1.6 billion per annum to enforce the drug laws in the UK, but our own Home Office's research shows that this is completely futile. It doesn't impact drug availability. The toughness of our sanctions have no impact on drug use, and prohibition creates unintended consequences, some of which we've heard of already today. And this can include the negative impact on employment, parental imprisonment, which has dire consequences for those children, and increased violence in the drug marketplace. And a lot of people suggest that drug policy is itself a gateway into further drug use and more offending. So if young people have their first brush with the justice system for a minor drug offence, this is what really drives that further drug use and further crime because their opportunities have been restricted. Imprisonment for drug offences is harmful and frankly nonsensical. We know that prison, nowhere are drugs more rife than in prison. A large proportion of men and women entering prison are already dependent on drugs. And then we know that 15% of people whilst in prison develop a substance dependence. And so prison is doing nothing for their rehabilitation and doesn't address the offending behaviour and the policies that are largely driving this behaviour. And in the UK, we have got a prison expansion programme. So currently we are building more prisons, and I'll talk about that a little bit later. So really horrifying carceral fever in the UK with this prison expansion, which seeks to build 18,000 new prison places. And final question, are there any health benefits with our drug policy? Is that the reason for these punitive policies? Is there a health benefit tied to it? It shouldn't be a surprise, but the answer is no. Criminalizing drug possession, we know, perpetuates stigma, marginalization, makes it more difficult for people who use drugs to access healthcare and support. We currently have the highest drug-related death rate in Europe and the highest on record since records began in the UK. And finally, during the COVID-19 health pandemic, when police were meant to be keeping their distance from people, we saw a 24% increase in stop and search under the main police powers, and the racial disparity continuing in the midst of this health pandemic. In the UK as well, the UK government introduced unprecedented new police powers under the Coronavirus Act to enforce the first lockdown with fines. And research by Liberty, the great organization, also found disparity, racial disparity with these powers. So people of color, 1.6 times more likely to be fined than white people. So in conclusion, carceral fever in the UK is growing. This is demonstrated, if I haven't already evidenced it, by the expansion of the prison estate, the increase in stop and search despite a global health pandemic, and the growing proportion of searches being for drugs. So that 69% has grown over the years. The skewed enforcement of drug laws exacerbates racial profiling, the hypercriminalization of ethnic minority individuals, and also disproportionately impacts people living in deprivation. So the global drugs war is actually about policing poverty, marginalized groups, and perpetuating social and racial control, and it must end. Thank you very much.
Thank you very much, Laura. That was very, very clearly exposed. So thank you so much for exposing these and really illustrating the carceral fever. And I don't think, as continental Europeans, we should rest assured that thanks to the channel, we are kept safe from these trends and tendencies. And I think you've really picked up on like Sean, on the fact that a lot of these criminal powers are based on they're not grounded in facts, you know, just like Sean was pointing out in terms of the charges, and also with Julien, that really resonates in terms of the disproportionate impact on specific people, on foreigners in France, on racialized people in the UK. So thank you very much. We'll turn back to you again on solutions, because I know that you have very clear ideas on how this can stop. But before I do so, I'd like to hand over to bring another perspective on Europe's carceral fever. Laura touched upon how policing powers of arrest and detention are seen to be used and documented, very well documented, which is something that at least is working in the UK in terms of statistics in that disparate way, and also pointed to the increase in policing powers during the pandemic. So here's the link that participants may be surprised about, but with Poland, with what we're seeing in Poland with this increasing policing powers, and how HFHR has documented their use and the extent to which they are related to restrictions in constitutional freedoms in Poland. So Marcin, over to you. Thank you.
Thank you very much. So I would like to admit that Poland has always had some problems with the excessive use of deprivation of liberty, especially in the form of pretrial detention. However, recently we can observe a clear link between rule of law crisis and use of deprivation of liberty and other forms of restrictions of human rights in the context of the freedom of assembly. So I would like in my short speech to address these issues. So first of all, our current government, the ruling party Law and Justice, imposed several restrictions on the freedom of assembly. And the first of such restrictions was introduced in 2016, and it concerned the introduction of the concept of so-called recurrent assemblies. So according to this law, assemblies which were organized recurrently in the recent years, especially to commemorate certain important historical events, could apply for a status of recurrent assembly. And such status, the benefit of having such status is the protection against potential counter-assemblies. It is prohibited to organize a counter-assembly on the route of the recurrent assembly or in a close proximity to it. And at the moment of adoption of this law, which may from the neutral perspective be perceived as neutral and objective, it was widely perceived as a tool to protect a specific assembly organized by politicians of the ruling party every 10th of each month to commemorate victims of the air crash in Smolensk in 2010. And this assembly was very controversial because political opposition and some NGOs believe that these assemblies simply use this catastrophe for political purposes. And that was the political background of this controversial reform. Nevertheless, despite this limitation, several counter-assemblies were organized even after adoption of this law, either despite this prohibition in violation of law or with the use of legal loophole in the law which allowed to organize a counter-assembly in the simplified procedure if there is no disturbances in the traffic. And in many cases, participants of such counter-assemblies were subject to various forms of coercion applied by the police, which I will address later on. Second set of restrictions was imposed on the freedom of assembly, was imposed during the COVID pandemics. And the scale and the exact content of these restrictions significantly evolved. At some point of the pandemic, organization of the assemblies was completely prohibited, while in some periods of time the prohibition concerned only organization of assemblies exceeding certain number of participants, from 5 persons to 150 persons, depending on particular time. And even though these restrictions may sound objectively justified on the ground of protection of public health, the problem was that they were introduced in the regulation, which is a sub-statutory act, what is in violation of Article 31 of the Polish Constitution, which permits on the introduction of such restrictions only in statutes, that is, acts adopted by the Parliament. However, once again, despite these limitations and prohibitions, many assemblies were organized, in particular after the announcement of controversial judgment of the Constitutional Tribunal concerning the access to abortion. Participants of these assemblies relied on the concept of spontaneous assemblies, which do not have to be notified in advance before the organization of such assembly. Nevertheless, in many cases, the police did not recognize legality of such assemblies, and as a result, sometimes used force and coercion against the participants. So police applied various measures of coercion, including deprivation of liberty, against participants of assemblies. And the Helsinki Foundation notes that particularly problematic was the approach of the police to protests held in 2020 during the COVID pandemic. And the attitude of the police officers was sometimes confrontational and contributed to creation of the atmosphere of fear. So we can distinguish several tools which were used by the police against protesters. And some of these tools could amount to deprivation of liberty, although not in the form of pretrial detention or imprisonment after conviction, but in certain alternative ways. So one of the most common measures applied by the police were identity checks. So some of the participants refused to provide their personal data to the police unless police officers give them an adequate reason to provide an identity document. As a consequence, police officers sometimes resorted to physical force to, for example, bring individuals to a police station for the purpose of identification. Sometimes the identification was done on the place of the assembly without formal detention of a person. Nevertheless, the police did not allow such protesters to leave the place of assembly for a relatively long time until the identification process was completed. Therefore, this situation somehow resembled deprivation of liberty, although it was not a clear arrest. Another practice applied by the Polish police is cordoning, that is surrounding the protesters by the police officers to prevent them from leaving the area until their ID is checked. This tactic was used, among others, in 2020 against participants of a spontaneous protest against the arrest of 2 activists and protest against tightening the abortion law after Constitutional Tribunal's ruling. What is interesting, there is a proceedings right now pending before the European Court of Human Rights concerning cordoning of protesters of counter-demonstration against Recurrent Assembly. And the applicant has been kept in this cordon for around 3 hours. However, neither the police nor Polish courts recognize this cordon as a form of arrest within the meaning of domestic law. So this will be very interesting to see what would be the approach of the European Court of Human Rights to this issue, especially taking into account that a few years ago there was a case of Austin and others versus United Kingdom, where the kettling was used against participants of assembly, was not classified as deprivation of liberty within the meaning of Article 5 of the Convention. Nevertheless, for example, the UN Human Rights Committee underlines that cordons should be used against participants of assembly only in some extreme situations, when there is a threat of violence, and only against people who are involved in violence. Otherwise, they can amount to violation of both freedom of movement or even freedom from arbitrary detention. Finally, in some cases, the police detained persons on the police station. This was applied mainly in situations where participants were accused of committing crimes. So generally, participation in an assembly, even unlawful assembly, is only a petty offense, not a crime. However, sometimes participants were accused of committing crimes such as taking part in a riot with a purpose to violate property or persons, or, for example, offending some police officers. Moreover, according to the Ombudsman reports, the National Mechanism for the Prevention of Torture, the police have sometimes arrested persons who just happened to be in the general area of the protest, but did not participate in this protest. And even though such detention was applied for a relatively short time, the reports of NGOs and National Mechanism for the Prevention of Torture show that the rights of detained protesters were violated. One of the most common problems was the lack of access to advocate, what may be perceived as violation of a convention and EU law. So according to publicly available information and our experiences as a Crisis Foundation, detained protesters were sometimes transferred outside the city limits, what prevented their lawyers to reach the clients before the first police interview. And as we know, this situation could affect the general fairness of criminal proceedings, because during this first interview, a person was deprived of access to legal aid. And the exercise to the right to lawyer often depended on the initiatives of NGOs and lawyers' self-organizations. Moreover, there were also information about unnecessary use of force by the police, which could be even qualified as inhuman or degrading treatments. And many such information was presented in the Ombudsman reports. Therefore, to conclude, Poland had serious problems with restricting the freedom of assembly via acts of law, as well as the unnecessary use of force and detention against protesters. And these problems, at least in my perspective, are connected to the rule of law crisis, not only through the fact that the government tried to limit the right to freedom of assembly, but also because of the elimination of the independent constitutional tribunal. Because of that, it was very difficult to challenge legality of these limitations. Luckily, despite many controversial reforms and actions of the authorities, Polish courts still remain to be independent, and so in many situations, court did not allow for repressions against peaceful protesters.
Thank you very much, Mohsen. Thank you all for painting a picture through your different perspectives of the far-reaching implications of this carceral logic in normalizing recourse to detention in its broader sense and in different shapes, as Marcin said, even the practice of cordoning by police. And now I'd like to go back to each of you in turn and think about different solutions that you've imagined, thought of, or even seen in practice in your respective areas of work and jurisdictions. I'd also like to invite participants to put any questions they may have in the chat. We still have just over half an hour, so we're on good time. Thank you, everyone. And in terms of moving on to the more solution building, at least just sparking ideas again, we aren't going to solve this here and now, but we want to try and start and participate in that. So can I hand over to you, Sean? You mentioned the chilling effect that your prosecution and detention has had on civil society work and volunteers going out to Lesbos. This is something as well, I think, that really resonates with what Marcin was describing in Poland in terms of using these different policing powers to restrict assemblies. Do you have thoughts, Sean, based on what you've heard in terms of how we could try to resist this trend?
Well, it's a tough ask, I think, to figure out how to end this. I think what we need to do is begin by understanding, I suppose, how this is happening. And then we can ask the question, why is it happening? And that might give us some insight into potential solutions. I think as to the first part, how is this happening? I think it relates to possibly the EU Facilitation Directive 2002, for example, which really defines very vaguely the difference between what is smuggling and what is, bona fide humanitarian activity. And in being so vague, it offers, I think, a margin of discretion to member states that might interpret this not in a way that resonates with, existing human rights obligations, and perhaps cracks down more than it ought to, certainly more than it ought to, on necessary humanitarian activity. And as I've said, we see that in the figures. This is not happening purely in Greece or even in border states, but happening throughout the entire European Union. There is, of course, just to pick up on why that might seem relevant to all of us. I think it's perhaps before I go on to the why is this happening, just to frame why it's so important. If you accept there's nothing special about what I did exactly what anybody on this call would do, which is to provide assistance to people, in distress. Then what we've effectively done is criminalized the most basic of human interactions that we see, helping folks who are at risk of drowning. I think it's really important to keep that in mind, because when we ask the question, why is this happening? It is because the European Union doesn't view this problem through that prism. It doesn't view it as an issue of helping people in distress. It views it as an issue of illegal activity, smuggling. And this is why we see the kinds of pretrial detention that we do see and the kinds of threats of imprisonment that we're seeing at the border. What does it mean to say that the European Union views this problem through the prism of smuggling, for example? Well, what it tries to do is end smuggling. What it does is it has in place this, rhetorical framework, which is called the pull factor. The idea of the pull factor, which really informs the primary policies that we see at Europe's borders, is that the safer you make this journey, the more people will end up crossing into Europe. And of course, we want to stop smuggling. We want to stop people making this journey. And so we must criminalize or stop search and rescuers, because even if they don't directly mean to assist smugglers, they're doing so by their mere presence, which is quite an intuitive argument. And I certainly thought while I was in prison researching a lot of this, how naive am I being that I think I can help somebody in distress, and meanwhile people are ending up drowning in the ocean because of my activity, and all the while I'm exacerbating terrible illegal activity like what smugglers do at the border. Now, the truth is, of course, that there's no correlation whatsoever, neither positive nor negative, between the amount of search and rescue happening and the amount of people passing through it. The only correlation there is the amount of people drowning in the ocean. The point then is, well, if the kinds of the use of pretrial detention, the kinds of investigations and prosecutions that we see at our border are not stopping smuggling, because indeed search and rescue isn't directly or indirectly facilitating smuggling, then what is? Ironically, of course, it is the policy that aims to stop smuggling which causes it. And this is quite clear. You need to be in Europe, you need to have the correct documentation. We will have the correct passport or visa. The second point is that to be an asylum seeker, that is to gain international protection by asylum, you must enter the territory of your would-be host state. And finally, we secure our border. And those three facts come together to mean only one thing, is that we force people into undertaking smuggled journeys, because there, of course, are no safe or legal means for the vast majority of people to seek asylum. And so I suppose, to answer the question, what can we do to try and overcome this madness? It must be to investigate the kinds of policies that lead to this, and not only on an ethical or moral or human rights level, as I've already tried to outline, but based on their internal contradiction. They don't fulfill the very things that they say they aim to do. And so there's no merit to them whatsoever. Whether you buy into the need against smuggling or whether you come at this from a humanitarian approach, it doesn't matter. The policy doesn't work. And I think on that level, if we have that very honest conversation, it at least opens up a chink in the armor of Fortress Europe for us to begin to talk about the need for bona fide and human rights respecting policies.
Thank you. I think that's an incredibly helpful response to a very difficult question that you started off responding to. And it really resonates with what Laura was saying in terms of the harm, public health harm in particular, of drug policies in the UK. Laura, do you want to come back on that and expand in terms of how we can prevent that harm and just like the harm caused by actually anti-smuggling policy, equally the harm caused by drug policies?
Well, certainly, and I completely agree with Sean that the first step, and obviously I'm focusing on drug policies, but they are indicative, as I hope I argued, of an example of racial and social control by the government. But we need policies grounded in public health and social justice and human rights. And the thing that we can start with is the decriminalization of people who use drugs. So drug decriminalization so that people are no longer subject to criminal sanctions for possession of drugs. This is a first step. It's one that is backed by all UN agencies. It's supported by the World Health Organization. Over 30 jurisdictions have gone on to do decriminalization, not all well, but those who have done decriminalization well are experiencing improved physical and mental well-being outcomes, reduced drug-related death rates, reduced blood-borne virus transmissions, reduced offending and recidivism, reduced burden on the police resources, if we're to consider this, and savings to public spendings. In our Release's 2016 paper, another plug, A Quiet Revolution, and we looked at countries around the world who have adopted decriminalization. And I know that our executive director, Niamh Eastwood, will be talking in the real detail on the Thursday panel in this conference, if you want to learn more. But probably the most known example of decriminalization of drugs is Portugal. Many of you on the call may be familiar. In Portugal in 2001, decriminalized the use and possession of all drugs and invested in harm and treatment programs simultaneously, really important. They experienced amazing improvement in their drug-related death rate, HIV diagnosis. The proportion of the prison population sentenced for drug offences fell from about 40% to 15% since the policy, so huge improvements there. So good news is that there are great examples. The only thing that we would do differently, if I was to have my choice of what we would do first, is that even in Portugal, people who are found in possession of drugs must attend a local dissuasion commission to determine whether they're dependent on drugs, and maybe they can refer that person to treatment or order a fine to be paid, or another sanction, a civil sanction. Well, actually, we know that only 1 in 10 people who are using drugs are dependent and have a dependency problem. And so actually that could be a very costly waste of time for people who do not need that help. So in the UK, what Release would like to see is a no punishment model of decriminalization. That's what we see in Spain and the Netherlands and Uruguay. And it's also something we actually already have in the UK. So the good news is we know it's possible because we have a no punishment model of decriminalization for substances that fall under the Psychoactive Substances Act 2016, which is the other kind of important piece of legislation controlling newer drugs. So we know it's possible, so that's good. But obviously what we'd like to do long term and what we need is repair models to not only stop the harm now, which decriminalization would do for a large number of people, but also to kind of redress and make reparations for the harms to certain communities, marginalized groups that I talked about earlier, that could come about with the regulation of drugs. So the legalization and regulation, the creation of legally regulated markets, basically. And cannabis will be the first in the UK, despite our current Prime Minister's objections. We know that over a third of US states have legalized recreational cannabis. We've seen Canada, Mexico, Uruguay. We've seen progress in Europe with Malta, Luxembourg, Germany leading the way. So it will happen in the UK. And why that's a positive thing is that not only will it stop the criminalization of the 3 million that I mentioned before and more over the decades, but it will try, if done well, make those reparations for the harms of the past. So when it happens here, we need a social equity model of any drug regulation, but I'm particularly thinking about cannabis. And that's another piece of work that Release has just released, actually, a paper called Regulating Right, Repairing Wrongs, where we looked at the North American models of cannabis regulation and where it's been done well and where it's been done poorly. And where there's been a failure to embed principles of racial and social justice. At best, it's a big missed opportunity. And at worst, we've actually seen displacement in drugs policing. So we need to get it right in the UK. And our recent paper looks at how we could get it right. But to summarize, what we want to see is a model that recognizes that harm to particularly Black and brown communities from the war on drugs and the war on cannabis, because we know that it's the drug that brings the most people into contact with the justice system in the UK and beyond. We want one that automatically expunges criminal records for cannabis-related offences, automatically releases people from prison as opposed to overturning judgments, prioritises licences for people from communities that have been over-policed, transitions illicit cannabis suppliers into the licit market, reinvests tax revenue from that regulated cannabis market into marginalised communities, and decriminalises cannabis in conjunction with regulation, which Niamh might be able to go into more depth on Thursday, but it's ensuring that those who are still purchasing cannabis from the illicit market, which we know will continue, we see it in the US and Canada and beyond, there is an illicit cannabis market that continues, to make sure that they are not punished severely. Among others, do see the paper, but also to end on a positive note, that beyond just drug offences and beyond just cannabis, we saw that some jurisdictions, a handful, the best example I have of this is Baltimore in Maryland in the US. They used COVID-19, whereas in the UK and in other parts of the world, as we've been discussing, COVID has been used to increase police powers and state powers. Baltimore decided to use the COVID-19 pandemic to move away from the prosecution of low-level offences. So at the start of the pandemic, their state's attorney stopped prosecuting low-level drug paraphernalia possession and prostitution in a way to reduce the burden on the police, but also in recognition of the impact on the poorer, predominantly Black residents of Baltimore for these crimes. And a year later, they've announced that the policy will remain. And because it's been so successful, hundreds of arrests have been diverted, 78% were averted in the Black community specifically, and calls to 911 about these offences declined significantly over the time period too. So the public had no issue with this change. So that is, in summary, what I would like to do, and great news about some jurisdictions using COVID to further policy in health and human rights.
Thank you. Thank you, Laura, for these very specific ways forward. I was wondering if I could ask Morten to what extent that may resonate, in particular, the need for redress. You mentioned some examples of judicial redress being obtained in Poland. So that's the one angle. And then the other, just building on that example in Baltimore, of deciding not to prosecute low-level offences. Is that something that you could envisage in Poland, some sort of policy to advocate for in order to prevent the sort of policing that you documented during COVID?
Yes, so with regards to your first question concerning the approach of courts in times of COVID pandemics and not only to restrictions of human rights. So we have to underline that both the concept of recurrent assemblies as well as restrictions of freedom of assembly introduced in times of COVID pandemic were widely considered by the legal scholars as unconstitutional. Unfortunately, due to the situation in the Constitutional Tribunal, which can no longer be considered as independent and impartial body, there was no chance for the objective review of constitutionality of these restrictions. It is therefore no surprise that the law on the recurrent assembly was found consistent with the Constitution by the Tribunal, while the restrictions introduced in times of COVID pandemic were not submitted to the Tribunal at all. However, to some extent, protection of freedom of assembly and because of that also protection of personal liberty was to some extent provided in the case law of ordinary courts. So with regards to recurrent assemblies, ordinary courts interpreted the Act on Assemblies in the light of the Constitution and the ECHR and held that priority status of recurrent assemblies does not affect the right to organize assembly in simplified proceedings. Therefore, it was possible to hold legal counter demonstrations against recurrent assemblies, provided that they do not disrupt the traffic. And we as a Helsinki Foundation participated in various judicial proceedings in which this interpretation was adopted. Unfortunately, the domestic authorities still sometimes tried to prevent the organization of such counter assemblies by prohibiting them, despite there was no legal basis for such action. Also, the restrictions imposed in times of COVID pandemic were questioned in courts. Courts recognized the unlawful nature of restrictions imposed via regulations and sometimes acquitted defendants accused of violation of COVID prohibitions due to inconsistency between these regulations and the Constitution. Because as I already mentioned in my previous speech, these limitations were introduced not in the statute, but in the regulations. Moreover, Polish authorities of Polish government officially did not introduce the state of emergency in country, the state of natural disaster, what would also allow to introduce more far-reaching restrictions. And without this introduction, such complete prohibition of organization of assemblies could be perceived as inconsistent with the Constitution. Moreover, in vast majority of criminal proceedings against protesters, these participants of assembly were eventually discontinued. Sometimes the proceedings were protracted and very lengthy. Nevertheless, they eventually lead to positive results for the protesters. And in many rulings, courts criticized the legal harassment of protesters or the instrumental use of regulations and creation of chilling effects. So the courts notice these negative implications of the restrictions of freedom of assembly. It is also very important to underline not only positive role of independent courts, but also role of civic society and law professions. Thanks to their actions, it was possible to provide detained persons with quick access to legal aid. So referring now to your second question, that is the approach of law enforcement authorities, then of course it would be very beneficial if Polish authorities adopted this approach and decided not to prosecute persons who are involved in some small offenses. Nevertheless, we have to keep in mind that there is yet another problem with Polish law enforcement authorities at the moment. That is the fact that the Polish prosecutor's office is not independent. Right now, the Prosecutor General and Minister of Justice, these two offices are merged. This means that there is a strict political control over the prosecution office and actions of prosecutors by political official, the Minister of Justice, who is also involved in adoption of very controversial reforms limiting independence of judges. And moreover, there are well-known instances of harassment against independent prosecutors who are sometimes transferred from their hometowns to locations a few hundred kilometers further. So in order to successfully implement this model in Poland, we'll probably need to implement first some institutional reforms, which will allow on more objective and more human rights approach to the prosecution of such actions.
Thank you very much. And now turning back to Julien, in France during the pandemic, we also saw that there was the biggest release of detainees, a certain category of detainees, in order to help clear a bit the prisons and accommodate social distancing measures within prisons. And I was wondering if you saw any opportunity in France for such more a longer term approach towards releasing people from incarceration or putting less people into incarceration, if you see any prospect for any long-term advocacy for this type of strategy. Thank you. Oh, you're on mute, I think, if you could.
Sorry. J'ai pas pour coutume d'être particulièrement optimiste vis-à-vis de cette situation, donc des perspectives concrètes, j'aurais du mal à en trouver. Je pense que y a vraiment peut-être une des phases sur lesquelles la discrimination que j'évoquais plus tôt se manifeste le plus, ça va vraiment être sur les aménagements de peine. C'est quelque chose qui est très problématique et on voit bien vraiment, comme je l'expliquais tout à l'heure, hein, c'est 25% de détenus d'étrangers dans les prisons, mais seulement 10% à l'extérieur. Et ça, c'est vraiment quelque chose, je pense, sur lequel il faut travailler, quoi. Y a plusieurs pistes d'explication, il n'y a pas que des choses sur lesquelles on peut agir. Il y a des études régulières, notamment une très récente, qui montre que les étrangers sont très représentés dans les délits qu'on appelle de flagrance, donc c'est-à-dire beaucoup de vols, de cambriolages d'établissements, d'effractions de logements, etc. Donc beaucoup d'infractions en lien avec une précarité sociale, encore une fois. Et toutes ces procédures de flagrance sont extrêmement fréquemment jugées dans des mécanismes de comparution immédiate, donc des jugements extrêmement rapides. Et ces procédures de jugement rapide conduisent à une incarcération dans la plupart des cas. Voilà. Donc, il y a peut-être quelque chose à changer aussi là-dessus, respecter davantage les droits de la défense, ne pas encourager ces procédures expéditives qui sont vraiment très très mauvaises pour les droits de la défense. Il y a un autre problème qui se pose régulièrement, c'est-à-dire que les juges qui vont prononcer des mesures alternatives, donc le bracelet électronique, la semi-liberté, donc c'est des systèmes où on peut dormir à la prison et travailler la journée. Ces juges ont besoin d'éléments matériels pour prononcer ce type de mesures, ce qu'on appelle des garanties de représentation en France. Donc ça peut être un travail, ça peut être un logement, ça peut être une famille, mais vont la plupart du temps demander des preuves, des documents, des choses. Donc forcément, on fait face aussi à une population qui, lorsqu'elle est en situation irrégulière, ce qui est souvent le cas, du coup ne peut pas présenter ces éléments-là et du coup subit cette discrimination. Voilà. Donc je pense qu'on peut encourager le développement de ces mesures, évidemment, même si on sait aussi que notamment le bracelet électronique ne doit pas représenter vraiment une alternative telle qu'on se l'imagine la plupart du temps. Ça reste un prolongement de la prison, ça crée des désastres dans les familles et dans les structures familiales et chez les individus. Mais il faut pour autant l'encourager pour qu'à minima, ce type de mesure puisse être prononcé dans les mêmes proportions que pour les justiciables français. Voilà. Donc ça, c'est quelque chose qui est important et puis je pense que ça passe par un renforcement aussi de la formation des magistrats à ces problématiques-là, à ces questions-là. Il y a beaucoup de magistrats qui croient encore que pour prononcer un aménagement de peine, il faut que le justiciable, que la personne soit en situation régulière, donc dispose de titre de séjour. En revanche, absolument pas. C'est une fausse croyance qui est très répandue. Il n'y a absolument rien dans la loi qui conditionne un aménagement de peine à l'existence d'un titre de séjour. La loi dit simplement que pour avoir un aménagement de peine, il faut avoir un projet de réinsertion, qu'il soit professionnel, qu'il soit familial, qu'il soit tout autre, ça peut être n'importe quoi. Mais la loi ne dit pas il faut un titre de séjour, voilà, absolument pas. Donc ça, je pense que déjà c'est quelque chose sur lequel il faut pouvoir dire, qu'il faut pouvoir diffuser un peu plus dans les formations, quoi. Il y a des juges, heureusement, il y a des juges qui considèrent que les démarches de régularisation, que le processus de régularisation et d'accès à un titre de séjour doit être considéré comme vraiment une partie prenante en fait du processus de réinsertion sociale, et donc ça peut permettre de justifier un aménagement de peine. Mais c'est des positionnements qui sont encore trop marginaux. Voilà. Donc c'est vraiment repenser assez structurellement la manière dont on punit en fait, et puis aussi repenser ceux qu'on punit, quoi. On a largement eu l'occasion d'entendre, j'ai oublié son nom, mais des développements sur la politique relative aux stupéfiants, voilà, qui montrent aussi cette absurdité de poursuivre cette politique. Ça a aussi été dit vis-à-vis des migrations, mais une absurdité de poursuivre une politique qui ne fonctionne pas et de punir sans prendre en compte en fait qu'on va dans le mur, qu'on va vraiment dans le mur, quoi. Et ça a été, comme tu le disais, ça a été vraiment très bien démontré pendant la crise sanitaire. En France, pendant la crise sanitaire, on a libéré 13 000 personnes. 13 000 personnes, il y avait avant la crise sanitaire 70 000 personnes dans les prisons, quoi. Donc c'est vraiment considérable. Il n'y a absolument pas eu de hausse de la délinquance pendant cette période de libération massive. En revanche, les étrangers, là aussi, ont été discriminés. Les étrangers sont beaucoup moins sortis que les Français, pour les raisons que je viens d'expliquer, hein, parce qu'on pouvait sortir plus tôt, c'était ça en fait. On n'a pas libéré des dangereux criminels, on a libéré des gens dont le reliquat de peine, dont le reste de la part en fait, à subir était très court. Mais pour autant, il fallait quand même pouvoir justifier d'un socle social, professionnel, familial. Et là encore, on a vu qu'il y a eu une discrimination vraiment basée sur des considérations administratives, quoi. Donc ça, c'est quelque chose qui est très critiquable. Voilà, c'est toute une période pour laquelle la délinquance n'a pas explosé du tout. On peut voir qu'évidemment, on peut vider les prisons des personnes les moins dangereuses. Et c'est en fait, cette phrase ne va pas. C'est-à-dire que l'extrême majorité des personnes en prison ne sont pas dangereuses. C'est vraiment une fausse idée qu'il faut déconstruire aussi. Plus de 99% des gens en prison ne représentent pas un danger pour la société. C'est une société à l'inverse qu'il faut changer pour que les gens n'aient plus à s'inscrire dans un cercle de délinquance, quoi. Voilà, donc c'est pas de solution miracle, mais voilà, des changements profonds plutôt à opérer, quoi.
Merci beaucoup pour ces observations qui sont extrêmement pertinentes et contribuent vraiment, just going back to English, what Sean was saying on this need to have an honest conversation of stating facts such as there are actually very, very few genuinely dangerous people. Stating the fact that if we carry on with the criminalization approach, if it comes to people, we've heard from Sean, people smuggling, from Laura on drug offenses, we're just going straight into the wall and participating and continuing to feed into this carceral logic. And an honest conversation as well about the different policy solutions that are put forward, and that they may actually have discriminatory effects, just like the release efforts in France during COVID, but also when we hear about alternatives to prison sentencing, how they actually, in this case, disfavor foreigners in France, for instance. So all part of a very honest conversation that we are having here, and I'm very grateful for that. We're coming up to time, and I see that there's a couple of comments in the chat from Joanna. Joanna's mentioning that we will be pursuing this discussion on Thursday, exploring decriminalization models. So I will definitely invite you to join our discussion, our further webinar on Thursday, where we'll be discussing further this route. And there's the information there in the chat. And before closing, I also wanted to invite each of you to take a minute or two to wrap up with a key takeaway from this discussion, from what you've heard. It could be very much sparking an idea, whatever you feel like sharing, and hopefully something quite positive that we can take away and try to continue working on. So shall I start? Shall I pick, or does someone want to start?
I'll start quickly,
Laura.
because I just wanted to say it was wonderful to hear everyone talk, and definitely we'll pick that up on Thursday. But I think that maybe an idea that I've had from everyone talking today is that we should recreate all of our previous analysis with nationality. Obviously I've been talking a lot along ethnicity lines, but I think that would be really interesting to look at nationality, immigration status, and how that impacts drug offences, drug law enforcement, disproportionality, if it's possible to research. And if it is, we should definitely do it. I think that would be really fascinating to look at.
and really relevant as well in the current EU initiative to start collecting equality data, where obviously nationality is one of the criteria that's looked at. Thank you, Laura, for that thought. Julien, do you have a takeaway before we close?
Pas vraiment, enfin, ouais, je regarde le micro, c'est bon. Oui, enfin, oui et non, en fait. Ça n'a rien de rationnel ou de politique, même si tout est politique. Donc, en fait, peut-être que si, mais je pense pas qu'en tout cas, ce soit l'intervention du droit, que ce soit l'intervention de la société civile qui puisse changer quoi que ce soit. C'est peut-être très utopiste ce que je vais dire, mais je pense que ces politiques, elles sont menées tant qu'il y a une demande, à tout le moins une demande passive en fait de la population, une acceptation par la population. Et la seule manière de prendre de court cette politique de l'offre, finalement, c'est de manifester c'est vraiment de manifester une opposition, de dénoncer l'absurdité de cette politique, l'archaïsme aussi de cette politique, le désastre qu'elle crée chez les individus qui les subissent. Donc la société civile est un moyen, mais c'est pas suffisant pour moi. Le droit est un moyen, évidemment, mais c'est pas suffisant non plus. La seule façon de procéder, c'est vraiment de briser les a priori, de briser les présupposés, de favoriser les rencontres, les échanges. En fait, c'est de là que tout part, en fait. De favoriser les interactions entre des populations qui se croisent pas, en fait, qui se parlent pas. Donc il y a une faillite, évidemment, politique, économique, sociale, urbanistes sur ces 50 dernières années qui font qu'on en est dans cette situation. Mais on a aussi une société, c'est pas pour critiquer, on a une société de plus en plus repliée sur elle-même, individualisante, faite de fantasmes de l'autre, d'idées reçues qu'il faut déconstruire, voilà. Donc, par ces rencontres, par ces interactions, et ensuite les politiques suivront, en fait. C'est simple.
C'est très simple, yes. Deconstructing representations, widely held social representations. Okay, second, yeah, excellent point. Thank you, Julien. Marcin.
Yes, so it was very interesting to me because my presentation focused on the institutional problems like the threats to rule of law, the approach of legislator, approach of courts, while other speakers focused on other problems. It was very interesting, and your comments were were of course correct for me, because you underlined that the problem with excessive use of deprivation of liberty is not necessarily connected to flawed law, but also to some stereotypes, racial prejudices, and so on and so on. So for me, what is my conclusion from this panel is that in order to resolve this problem of excessive use of deprivation of liberty, we'll probably have to analyze what are these extra legal factors which contribute to excessive use of deprivation of liberty, and to those factors which you mentioned, I could also contribute some other factors, like, for example, legal populism, the belief that the deprivation of liberty is the only solution to resolve certain social problems. This is approach presented, for example, by our Minister of Justice. That's when there is a social problem, the solution is to increase punishment in criminal code, and we know that this is not a correct answer. So this is a very interesting point to me.
Thank you, Martin. That's great. It's yeah, I think this is really exactly what we're hoping to continue discussing on Thursdays, how we can contribute towards identifying these extra legal factors and really combat this idea that the solution is increasing powers of punishment, increasing policing powers, increasing recourse to detention. And you started, Sean, and now I'll ask you to conclude with a final remark, a takeaway. Thank you.
Yeah, I was hoping you'd ask me last because I really have no idea. But I think what I can try to do is summarize what was just previously concluded, and also try to link it back with what I started with. And that is that the use of pretrial detention, the kinds of prosecutions we see, they must have some root in a sociocultural foundation. And I think that, you know, what Julien, for example, said is that we need to I think reach that level. I guess what I'm driving at is the reason that there can be policies, there can be institutions that are so painful and that do put people into detention. They can only operate because there must be some consensus that the people in them deserve to be there. And to try and break that down, that narrative, that sociocultural narrative, must be to some extent the starting point. Conversations like this, I think, are helpful, But, this is a wider public issue, and just changing the debate and finding the frames to change that debate for me have been really important, and I guess to some extent self-interested hobby of mine, or interest area of mine. And I think that in recognizing that it is a cultural issue or a sociocultural issue, it almost makes the task a bit easy, because all we have to show is that the people in prison don't deserve to be there, and they don't. And that shouldn't be, hopefully, the most difficult task that we face.
Great. Thank you so much. I think that is documented, showing, not even about documenting sounds so formal, but really who is in prison, and demystifying, breaking down those narratives. It's really the common conclusions that you've all reached, and it's so interesting to hear, coming from such different perspectives and jurisdictions, that we've all got there, and also that it resonates very much with what we heard earlier from an institutional perspective, that legal reform can take us that far, but that ultimately it's feeding into this broader cultural narrative that is very difficult for a policymaker on their own to be working up against. And so it really calls for collective cross movement engagement, cross-sector, cross-profession, and that's why we were very happy to bring you all together today and to continue our discussions on Thursday. The information is in the chat. Thank you very much to everyone. Thank you to our speakers, our panelists. You are absolutely brilliant. Thank you to the interpreters and to the team, the whole Fair Trials team, for making this all possible. Thank you so much. And we'll keep on the discussion and breaking down those narratives.